Everyone, good afternoon. So we're here today to talk about avoiding defamation claims. So before I even introduce us, here's a question for you. How many of you here today are worried about defamation? Wow. Okay. How many of you have been threatened with defamation? Okay. And how many of you have been sued for defamation? Whoa. Okay. We want to give you the power to know what the elements of the law are so that you can either defend yourself or, I suppose, bring a defamation claim. So I am a person, I raise my hand under threatened with defamation because when I was working on an investigation, 2020 probably, I was told that the organization would sue me for defamation if I put a report, an investigative report that I had done on Facebook. And so for those of you who were threatened, and I see you again, did it bother you when you were threatened? Yeah. Did it scare the bejesus out of you? Because it scared the bejesus out of me, and I'm a lawyer. And I know how frightening that this can be. So as I said, knowledge is power. We're going to go through some of these elements. We're going to talk about the things that you can do. You can never eliminate the risk. Somebody yesterday said, did you say it, Deanna? You said, anybody can sue for anything. I practice in Massachusetts, and the Supreme Court decided that even if you're dead, you can sue. So wow, there's no state of no's. But what we can do is lower the risk, which means that there's a lot less chance that somebody will come after you. Okay, so here we are. I'm going to introduce Pamela over here. She is not just the Vanna White. Could be. And we agreed that we would introduce each other. So what I have to say about Pamela is we've worked together for a couple of years now. She's stationed in the UK. She's based in the UK, but she's a US lawyer. And we've done some amazing work. She's a brilliant lawyer, way more than I am. And she's also, this is really important, she's local to Montreal. So if you want to know where to go to eat, please, you're a person. But most importantly for our discussion today is that she won with our team an anti-SLAPP lawsuit against one of our clients. So anti-SLAPP means there's a growing movement in the United States to say that defamation claims, which are frivolous, which are baseless, should be able to be dismissed because it's speech in the public interest. And so in New York, Pamela and our team won a case for our client. So we're going to talk about that.
Yes. Cal Murchison needs no introduction, perhaps. She is known as the cult assassin.
She's one of the only soldier in an army without weapons.
That's it. One of the only people I've ever met to come out of retirement to work harder. But she has a background in employment discrimination and training basically companies on how to not discriminate against their workforce, which is, I think, shockingly hard to do. And that has been really helpful in kind of figuring out some of the dynamics at play in some of our cases. So yeah, we've together since I joined in April 2023. I want to say we've brought 8 lawsuits, all cults, some settled, some ongoing. So
more on the horizon.
So yeah, that's us. And here, this is kind of some of the goals we have for today. We want you to be able to speak out with less risk. I think that the risk here is not of the people bringing the lawsuit. We can't control that. As Anna said yesterday, we cannot control whether a person sues you. I guess what we can help you with is whether that lawsuit is successful or not, and whether, how strong the claim is. This is not legal advice. Though we are lawyers, this is not legal advice, and we urge you to sort of seek your own counsel. We just want to give you some of the basics here today. And the law that we are using is based on New York law. As you'll see in some of the slides, it's very old. It's based on English law, kind of 18th century. Still, some of the terms still haven't changed. You'll see talking about the chastity of a woman in one of the slides. And so it's actually fairly similar across U.S. states and also in other kind of Commonwealth countries. But the law we're using is based on New York law.
Okay, so here's what we want to talk about. We want to talk about what is defamation. So once you know what the elements are, then you will be able to see the things that you can do, as Kamala said, to make a lawsuit unsuccessful, but also hopefully to make it so that the person who wants to sue you for defamation will go to a lawyer and the lawyer will say to them, you can't win this. Don't do it. That's another possibility. So we want you to know what is defamation. We want to talk about anti-SLAPP. SLAPP is strategic lawsuit against public participation. That means when the court can see that the person who is suing you is bringing this in order to silence you from speaking about something that the rest of the public is interested in hearing and that protects the public interest. It's not that they can't sue you. It's that there's an escape route, a pretty quick exit ramp. If you were in that session this morning, I was amused by that, takes a long time to do. Litigation is very long, but this is a fairly quick exit route.
Yes.
And so we want to talk about anti-SLAPP. Now I was going to take you through a case study, and we're going to talk about the practical ways to avoid it and, of course, wrap up. Questions. If you have clarifying questions as you go along, and by that I mean, I don't understand this, what is she actually saying? Then ask them, ask them, just raise your hand and we'll take that question. Because undoubtedly, if you don't understand what we're saying, nobody else does either, and we don't want that. We want you to understand. So clarifying questions, ask them as you go along, just raise your hand. For deep dive questions, discussion questions, we'll leave time at the end that we can take some questions. Okay? Okay. Defamation 101. So here's what I want to do. I want to pretend that we have an organization. It's a cult organization, and in fact, the name of it is the Foundation for Ascension, Knowledge, Energy, and Secrets. That the acronym is FACES. This is an organization that some of you have been involved with, and you would like to speak out again because they have been doing absolutely horrible things. So what you want to know is, what can the fakes, what are we looking for when we're talking about defamation? So the first thing about defamation, and these are like check off the box. It's just not quite that simple, but it's really like, what do you need to prove? If I am representing the fakes, then I need to prove that it was a false statement of fact. So if Jackie said something that is false, then I've satisfied the first element of defamation. The second thing is, it has to be published to somebody. So if Jackie just thinks it, or if she's walking down the street and she says, I really think that the fakes are a bunch of fakes, then that's not published to somebody. That's what they mean by publish. They don't mean necessarily in a newspaper, but that's the word that they use. Causing reputational damage. Reputational damage. So if I say something that's false to Pamela, but it doesn't cause the person any damage to their reputation, it's not defamation. Okay? And finally, done negligently or with actual malice. And we'll go into this, which means that I wasn't careful about what I said. I should have done more fact checking. Okay. So a lawsuit is a little, I don't know if any of you have been watching Wimbledon. but it's a little bit like a tennis match. So over here on this side of the room, I'm going to represent the fakes. They want to bring a lawsuit against you because of the things that you have said. So it's a little bit like tennis. I take my ball, and on the ball, I'm going to say that first element. You said something that was false. I'm going to hit it across the net. Panel is going to represent you. You're in good hands.
I agree. So I think, what I'm going to say is all of my statements said, I think, I feel, in my opinion, or reporting on a lawsuit. The lawsuit alleged, the complaint said, one of the witnesses said, the police report says. So all of these are facts that I've relied upon from outside sources that are in general privileged, and we'll go into that a little bit later, but in general facts that I'm allowed to report on. And if I've talked about my own experience and what happens to me without using inflammatory language, that's what Carol called the Advil rule, and I will talk about actually why some inflammatory language is okay, but without sort of saying, for example, XYZ is a rapist, rather than when I was there, I was sexually assaulted. And it's taking name calling and turning it into an experience.
So are you saying that what your clients have said is the truth?
Correct. It's true.
It's true. But listen, truth is a defense. Yes? We hear that all the time. And that is true. Truth is a defense. However, when do you get to prove the truth?
Yeah. The sad thing about the truth is it takes you all the way to the end. So you cannot dismiss a lawsuit by saying that something is true, unless it's something so obviously true that a court would probably throw it out. So in order to get to the truth, you have to have witnesses testifying under oath as to what happened, and you're able to sort of say to the court, look at all this evidence. It's very clear that it's true. But by then, you're sort of already deep in the process, and you've had a lot of trauma as a result of that. So it doesn't get the lawsuit kind of kicked out.
So instead of relying on the truth, which you can ultimately rely on, but more like better from a risk perspective is to use this, what Pamela talked about, verifiable facts. Somebody else reported. The New York Times reported. And when you say what the New York Times reported, you say the New York Times reported. In other words, you do your own fact checking as you go. Opinions, First Amendment. First Amendment protects religions. It's a thorn in our side as we try to litigate against spiritual organizations who were not religions yesterday, but who are today after they are sued, so that they can take advantage of the First Amendment. However, the opinions is also your opinion, your free speech is also protected by the First Amendment. So when you are writing or speaking, make it clear that what you're talking about is, in my opinion, this is XYZ. Then Pamela mentioned the Advil rule. Even I looked at that, Pamela, and I thought, what that means? Well, she wrote it. It's inflammatory language. You want to be very measured. And you want to be clear about what you don't know. So you can say, I don't know whether this happened, but in my opinion, and then you can go on. And here's some very helpful thing, is that you can rely on police reports and complaints that are filed in court. So in all of our, well, not in all of our cases, but in many of our cases, we do very fact-intensive complaints that we put into the court, and they are on the public docket. Anything that is on the docket cannot be the basis for defamation. We often do this because our clients want to have some kind of media coverage, and reporters are more apt to be interested, Deanna, when it's in the complaint, because they know they can't be sued for repeating what's in the complaint. So you can rely on court docs or police reports. Okay, publication. This is the second thing. Now remember, I'm representing the fakes. And so I'm going to say, I'm going to bounce my ball here and put on it that You not only said a false statement, you published it to a third party. I'm going to hit that over the net, hopefully, to Pamela.
Fake lawyer. All I did was send you a letter and say, here's what happened to me. I'm gonna sue you. Please get in touch with me. If I said it to you, you are basically an agent of the fakes, are you not?
Well, but what if you sent it to the board of directors and you copied them on that letter, Miss Pamela?
The board of directors is also you. So that is still just not published to a third party. That's still just directly to you.
What about the article that they posted on Facebook? Uh-huh.
Not me fakes.
All right. So you see, if it's communicated to a third party, it doesn't include the lawyer. It doesn't include, and often it doesn't, well, it doesn't include police. It doesn't include maybe a tribunal or an agency. But if you publish it on Facebook, then yes, it's published. Now, republication.
Yes. So every instance of that publication, so let's say, you put it on your Substack and then you publish it on your Facebook. Each of those is a suable claim. It's not just, each time it's republished, it's could be another claim.
So I'm on the third element that I have to prove as a fake lawyer for the fakes. And what I have to prove is that the reputational damage of the organization happened because of this. Now, look, the court, I don't have to prove this for the fakes if what the thing that you emailed said, I've been charged with rape. Or you're saying that I'm a rapist. If you're injuring my business or profession, if you are accusing me of having this is the 18th century language, a loathsome disease, or if you are talking about the unchastity of a woman. So take notice here on the loathsome disease and the unchastity of a woman. If it's this, I don't have to prove anything for the fakes. But if it is something else, I have to prove the damage. Now, look how this works out. If it's already been in the New York Times, if there's already been a court hearing, if there's already been a wide range of things out in the, in the air about this organization, can I really prove reputational damage? Maybe not. Some people are libel-proof. This is not something to aspire to. This is people whose reputations are so bad. No, they actually they can't prove damage. And these two things must be of and concern.
Yes. So this is directly kind of emanating from the lawsuit we dealt with. We have a guru who is deceased, this is a historical lawsuit. So the lawsuit alleges that he sexually assaulted our clients, and the organization says that was defaming them, that the statement about the sexual assault defames them. Well, he's dead. So he doesn't have a reputation that is allowed to be sued for. And so the actual statement has to be about the actual organization or the person. It can't just be kind of, the leader of an organization. So for example, if you say, that's Steve Jobs, he was an asshole, Apple can't then sue you for that kind of damage. The other
if he's dead. Yeah. Okay, good. All right. I think I'm at the end. No, I have to prove.
Are we on this?
Okay. I have to prove that you did this negligently, like that you didn't do your fact check. You relied on rumor, you relied on gossip. I'm going to put that on the ball and I'm going to hit it over the net to Pamela, who's representing you, to say what, Pamela?
Well, I'm going to say, I have just talked about your leader, and your leader is actually has put himself in the spotlight, has called himself a god, has declared himself the savior of the universe, and therefore he is a public figure. And as a result, it's not just negligence. You have to prove that I said this with a complete disregard for the truth. So, in other words, I didn't quote the New York Times. I didn't quote complaints. I just made it up out of whole cloth, or that I knew it was false and I said it anyway. And that's a higher standard and more difficult to prove in court.
You see, it's harder to prove malice. And particularly if you do your fact checking and you are very, very careful, like journalists are, about not being inflammatory, not relying on all those things, it becomes impossible to prove malice. Okay, so libel, we've talked about libel, slander. Here's the way I remember it. I always get confused with this. Libel, I think of L for letter, meaning writing. Things that you write, Facebook, email, text, that is libel. Slander is S for spoken. Now, the good news on this for Pamela, maybe not for me representing the fakes, is that the statute of limitations is typically short.
Yes.
1 year to 3 years.
Yes, 1 year to 3 years typically. And I should say that libel versus slander, I think in New York, for instance, it's just all called defamation. Defamation's the umbrella term. Some states still have a discrepancy with the statute of limitations, whether the statement was written or spoken, or maybe a difference in the law. So be on the lookout for that. But yeah, statute of limitations is typically short, 1 to 3 years, and it's typically fairly strict. In other words, it's not sort of, oh, I just discovered that this was written in the New York Times, 10 years later. That sort of doesn't matter when they discovered it or not, typically.
Okay, so I think now that I have made all of the elements that I told you that I needed for this claim. Can you go into the next one? Let's see if I did. Okay, so I've made the elements. I've done all of the check off the box that I needed to do. I put that on a ball. I bounced it over the net to Pamela. She has some defenses to this, but remember that in a typical case, we got to go to trial to figure that out. But she has another trick.
Yes, and I should say that a statute of limitations actually is usually enough to kind of get it dismissed. So if it is with, outside the bounds of statute of limitations, usually a court is like,
That's true.
get out of here. So I'm assuming the fake, you've sued me in time, right? Fake? Yeah. Oh yeah. Okay, good.
I'm not a fake.
You're not a fake. So so one of the things that courts and legislatures have recognized is that a lot of times a defamation lawsuit is just used as a tool to silence people. And increasingly, I mean, New York just amended its anti-SLAPP law in 2020 to really cover the breadth of the types of lawsuits that touch on issues of public interest. So a SLAPP suit is what the fake lawyer did to me. It is merely a lawsuit to burden me with costs, to threaten me, to send a signal to all other people who are speaking out to shut up. And courts have basically recognized that defamation cannot be used as a tool of abuse in that way, and have labeled these lawsuits a SLAPP suit. So I'm saying this is a SLAPP suit, fake. And I think that anti-SLAPP law is basically the elements to meet this anti-SLAPP law is we have to put forth that this is a lawsuit that is about a statement that was made in public about an issue of public concern. So in our lawsuit recently, we argued that sexual assault is an issue of public concern. And the defendants had basically already said that our clients allegedly made these statements in public. They had admitted that, so we didn't even have to make a lot of arguments about that. And usually, and that's typically actually all you have to do in order to say this is a SLAPP suit and it should therefore be dismissed. In New York, it puts you on a fast track to dismissal. It basically says everything else is stayed in this case until we decide this lawsuit. And the deterrent factor is that you get attorney's fees. Now, it is very, very rare in the US system to get attorney's fees. The system is each side pays their fees. You really have to be egregious to get attorney's fees. So the fact that this law awards attorney's fees is a serious deterrent for people bringing SLAPP suits.
Because when Pamela hits the SLAPP suit back across the net to me, I'm going to say to the fakes, look, you may have to pay their attorney's fees.
Yeah.
And let me tell you that they add up very, very quickly. And so I have to, as a lawyer, advise my clients that the things that you did over here that were good, all of the things that we said that you should be doing, fact checking, not labeling as opinion, not being inflammatory, telling what you don't know as well as what you do, using my own experience, what I know. When you've done all those things, I, as the fake's lawyer, are going to say to them, you know what? I'm not sure you can win this. And if you don't win it, it's not just losing, it's paying attorney's fees.
Yeah. And as of June 2025, 38 states and DC have anti-SLAPP laws. Sometimes it's sort of hard to know if they have anti-SLAPP laws that would protect in this context. Sometimes they're sort of limited. So make sure you're checking it out in your state, please. This is not legal advice.
It's not across the board. Every state has a different one. And by the way, some states, some countries, Canada, for example, doesn't have an anti-SLAPP law, but I think they have journalistic expression laws, and there are other things in other countries that might also cover on this.
So we thought we'd just kind of give you food for thought, sort of a real life example that might happen to you. So you've been approached by a friend, also a former member of the cult you're in, about writing about your experience on her Substack. The subject of her Substack is about the cult. She has a few hundred subscribers, but this post would be available for free for anyone to access, so it's not limited to her subscriber base. District of Columbia have anti-SLAPP laws. Let's assume that they are, as I said about New York, very vast and would cover situations we're talking about. You want to participate, but you're aware that the cult has threatened litigation previously, defamation suits, and are ready to sue. What can you write? And if you are sued, what is your defense?
So let's ask.
What do you guys think?
What can you write? Absolutely. You can say, this is my experience. Can you say that you know for a fact somebody else's experience? You can't. I don't know this person's experience, but I know my own experience. What else? The opinion thing, I want you to understand that an opinion is not, in my opinion, he's a racist. I mean, a rapist.
Courts see, like, it's like the "in my opinion," while is a magic phrase in some ways, doesn't completely immunize you from liability in this instance. It's just helpful.
So in a certain way, you have to be able to, I bet people don't deconstruct sentences anymore. But in that sentence,
Yes.
like you said the very beginning of it, is a number of people have reported to me. If that is true, and if they said to you this, that, and the other, and that is true, then that's fine.
That the key is really, if you're ready to go under oath and say, this person reports me, that person reports me, that person, the definition of a number is perhaps a handful, and in common parlance, we're good. Then it's true, right?
So that's okay, yes. Really, we're like angels dancing on the head of a pin here in a way, but, I think you can say, I don't know.
I don't know. Yeah, exactly.
I think.
But I think it's possible that.
Well, it's also stuff gets read in context. That's also one of a really important maxim in these cases is you could take sort of a sentence out and perhaps go, but then if you've sort of able to look at it in context and it's very clear that, you've said, I don't know, I'm not sure, this person was cautious, but I believe, blah, 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 then I think within context, to me, that looks defensible, but it's up to a court.
So
Your own lawyer, it's not legal advice.
in this case, in this Substack article, if it gets printed and published, and it comes to the attention of my client, the fakes, and they come to me, their fake lawyer, and then I've got to be saying, when I'm hearing what's in your article, I'm not even going to want to sue you because I can't win. And if I'm under anti-SLAPP, I'm going to have to pay attorney's fees. Anything else that people have that they want to see on up here about what you can say? Yes.
Wow.
I'm only to say Johnny Depp, right?
Yeah.
So the article that Amber Heard got sued on never named him.
The court would say if it's enough that you could reasonably identify the person, then Yeah.
10?
Yeah, 10 minutes. Yes. So this is just some of the things that we said here. I feel, in my opinion, senses they don't completely immunize you, but they help. Hyperbole, okay, and I say that because in some cases it's like it the question whether or not it is opinion comes through by the way you're speaking. Like, oh, that dude was the worst, and that kind of language makes it clear that you're not aiming to be viewed as a factual source. You're aiming to be just presenting your opinion because you're clearly acting like yourself. Avoiding names, we already talked about that. It discussing lawsuit alleges, the report found. I think about the context again. So in the case study, this already goes to people who are looking for who are getting information about this cult. Your statement is not going to be the first piece of damaging information that's released about this cult. So that's another defense that you would have.
So I might not be able to claim damages, which is one of the things that I have to be able to prove.
Yes. And it will be SLAPP. It could be considered SLAPP. So just to wrap up, use citations, refer to what is published in a kind of ascertainable source so that you're not making a statement negligently or with actual malice. Use personal statements. We've talked about this. Talk about your experience rather than labels. In my opinion, I believe allegations reported, and your homeowner's insurance might be helpful for you. Some people's homeowner insurance, if you are sued, gives you a kind of money to defend yourself, and some of them actually do have carve-outs for defamation, but some don't. So have a look if that is a position you're in. And like I said, we can't. These tips will not help stop you from being sued. If someone wants to sue you, they'll sue you. It doesn't, sometimes it doesn't matter what you say. So this is a risk you take on, and these are just some tips to help you stay out of trouble. Questions?